Any land that is jointly owned will not go to the succession course. So, fathers, men, if you want your wife to own the property, immediately you die before the side chick comes to fight for that land, register the land jointly. Either jointly with your wife or jointly with your children. So that by the time you are dead, they only take the death certificate to the registrar of lands. The title deed is cancelled, your name is removed, and the name there is replaced. You are buying land. Yet, that is where the animals from the national park pass to go to the river. Those animals have a right of easement. The national wild animals, if that is the route they use, that land you cannot sell it, whether it is yours. That land might have minerals down there. You cannot be allowed to get, it is your freehold land, you can't get the minerals down there. Do you know there is a Warma Act? It is your land, it is your ancestral land, but you cannot dig a borehole without the county government giving you the license and you paying every year to the county government. This is episode 2. We are dealing with the terminologies in this episode. Interpretations, the terms that are used in this act. We are dealing with the Land Act Cap 280 of the laws of Kenya. We hear very many terms that we don't know what they mean. Let us start alphabetically. You have heard what is called a certificate of lease. Originally, it was called a lease. Today, this is called, the meaning assigned to it, it means anytime you get land from government, either county government or national government, they give you a lease. They don't give you a title deed. Number 2, certificate of title. Originally, people used to have a title deed. There is nothing anymore called a title deed. It is called a certificate of title. This is now the document that shows you ownership. Third, we have what is called a charge. A charge is when you take that certificate of title or that certificate of lease to the bank. The bank evaluates the land, gives you money. That after the bank has given you a loan, it takes that title of yours and puts a charge on it. You cannot sell that land, you cannot transfer that land because it is charged to the bank. It is mortgaged to the bank. So the instrument that shows that this title has a charge is normally captured at the encumbrance side of the certificate of title. So when you do a search, you'll see an encumbrance where it says a charge or a mortgage charge to KCB Bank, to Equity Bank, to National Bank, to Cooperative Bank of 10 million shillings. You know that that land does not belong to that person. There is a charge on that land. There are 3 types of charges. 1, the normal charge, that is the official charge that we have talked. 2, there is an informal charge. This is written and witnessed undertaking So, there are witnesses who saw it. That is called an informal charge. Normally, in the village, it is not registered at the lands office. A formal charge must be registered at the registry, land registry. Lastly, there is what they call the customary charge. This is in the village where people know the customs. And it says, normally, a group of people use that land. That is a customary charge. You can't sell that land because there is a customary charge over that. We are still on letter C. Then we have compulsory acquisition. This is when the government takes your land for the purpose of building a hospital, building a military barracks, building a road, passing Kenya Power lines, SGR train passing there. The government will compulsorily acquire that land. That one is what is called. We have dealt with the term court. Court is the Environment and Land Court. Then we have now an issue. How do we own land? People don't know. There are several ways of owning land. This is very interesting. How? Sarah was asking me, land is owned by one person. No. There is what is called co-tenancy. Let me read what co-tenancy is, and you can see it here. It means the ownership of land by two or more persons in undivided shares and includes joint tenancy or tenancy in common. Joint tenancy or common tenancy is when, for example, you and your wife, the title is written in your names. There is no distinction whether Omari has 70% and the wife has 10%. It is joint tenancy. What does joint tenancy mean? When one dies, whenever one dies, the other person takes the whole of it. That is what is called joint tenancy. We shall be dealing with this as we move forward. Then we have what is called customary land. This is land owned by the community. Then we have what is called disposition. You have heard this term severally, dispositions. This is how can you remove your land from your ownership to other people. You can dispose of your land by selling. It's one way you can sell land. Number two, you can charge that land to a bank. Three, you can transfer that land. That is called disposition. Four, you can grant that land to somebody. Five, you can partition. The land was 5 acres, you partition it into what? 6, you can exchange that land. It's called swapping. Cyrus comes from Kitui, I come from Nyamira, we exchange. I give him the land in Nyamira, he gives me that land in that. You can lease. Land can be leased. You give somebody that land temporarily for a certain time. Use this land for 10 years. You pay me this amount of money. The land does not become his. 8, you can give an assignment. Cyrus has leased the land, but he's tired. He decides he assigns it to Omari. He goes away. Now Omari becomes the one who is having that lease. 8, you can surrender. Many school lands Many of the people who had land originally surrendered land to either the government. You can surrender the land to government. Remember the Ruaraka case, the Ruaraka land saga. The court found out that the owners had surrendered the land to government. People have surrendered land to churches. People have surrendered land to institutions, for example, schools. So that one is what is called disposition. Or you can, in all other issues, you have a way to release your land, either through an agreement, because every land transaction, there must be an agreement. We are on. What is a dwelling house? A dwelling house means any house or part of a house or a room used as a separate dwelling in any building, and includes a garden, kashamba kale kadogo kako nyuma ya nyumba is called a dwelling house, or any premise within the curtilage of and used as part of a dwelling house. So the dwelling house is not a permanent house only. It can be a kibanda, it can be nyumba ya mabati, it can be a small thing, it can be that small garden. That is what the laws calls a dwelling house. Very many people have been talking about what is an easement. If you look at the title deed, you will see an easement there. Every sale agreement will put a clause and any other easements. What does the law talk about easements? It is here. It means a non-possessory interest in another's land that allows the holder to use the land to a particular extent, to require the proprietor to undertake an act relating to the land, or to restrict the proprietor's use to a particular extent, and shall not include a profit. This allow me to explain further. You are buying land, yet that is where the animals from the national park pass to go to the river. Those animals have a right of easement. The national wild animals, if that is the route they use, that land you cannot sell it, whether it is yours. You can't, that is the land. 2, domestic animals. You have gone somewhere and you have been shown land and you see the animals, the cows, the goats, the sheep. Normally, Sasaba, they use that place to go to the river. That right is called a right of easement. You cannot fence that land because the animals go to the river. 2, the route where people pass to the river. Kale kachochoro, unauziwa shamba, and there are people who have been passing there to the soko, to the market. There are people who have been, children who have been passing there to school. There have been people who have been passing there to the shopping center. That right, you cannot remove it. You are buying land where religious ceremonies are conducted. A kaya is there. Sacrifices are conducted there. That is an easement. So when you buy land, make sure you check whether those things are there. You will not fence that land. Check whether there are squatters who have been there and they're using that land. Easement is a very technical term. People do not, because these are not owners, but they have a right of usage of that land. So when you buy, you find that you are fencing, somebody tells you, there were easements in this place. You now know. Freehold. When we talk about freehold, you need to understand what the law means by saying freehold. It says, any unlimited right to use and dispose of land in perpetuity, subject to the rights of others and the regulatory powers of the national government, county government, and other relevant state organs. Hii ni mashamba ya nyumbani. Freehold, you can be buried there, you can sell, you can do that land the way you want, but subject to national laws and county laws. How does the national law come in? How do I use land that is mine subject to the national government and the county government? Yes. One, if you want to sell that land, it is yours. You must go to the Land Control Board to approve you to sell. That is the control they are saying. Why? Land usage is a preserve of the national government and the county government. You cannot subdivide that land to pieces that the county government or the national government has said. It is your land. Two, that land might have minerals down there. You cannot be allowed to get, it is your freehold land, you can't get the minerals down there. Do you know there is a Warma Act? It is your land, it is your ancestral land, but you cannot dig a borehole without the county government giving you the licenses and you paying every year to the county government. So the freehold is not completely freehold. It is freehold subject, and that's why the act says subject to those regulations. Georeference and georeferenced boundaries. We had boundaries. The boundaries are normally put by surveyors. Originally, you could see them moving around with canvas, nyororos. Today, they use the georeference boundaries, digital way of marking boundaries. Sectional properties title. These are titles in apartments. There is a georeference data that marks the beacons of that land. Joint tenancy. This is the most important issue. Joint tenancy. God, Cyrus, hii tutapigwa na vita. Means a form of concurrent ownership of land where two or more persons each possesses the land simultaneously and have undivided interest in the land under which, upon the death of one owner, it is transferred to the surviving owner or owners. Any land that is jointly owned will not go to the succession course. So, fathers, men, if you want your wife to own the property, immediately you die before the side chick comes to fight for that land, register the land jointly. Either jointly with your wife or jointly with your children. So that by the time you are dead, they only take the death certificate to the registrar of lands. The title deed is cancelled, your name is removed, and the name there is replaced. This is the only way to avoid disputes that we are seeing in succession courts. It is called joint tenancy. Then we have a lease. What is a lease? It means the grant with or without consideration by the proprietor of land of the right to the exclusive possession of his or her land, and includes the right so granted and the instrument granting it, and also includes a sublease but does not include an agreement for lease. So the lease is where the owner, mostly the lease is government land, county land. It gives you to use for certain years, not more than 99 years. Omari has land. I lease that house. It's a business land. It is a business premise. I lease it to you for a certain duration of time. So, the license. What is the license? Not a driving license. Cyrus tells me I need to explain why a license in land. It means permission given in respect of public land or private land. You are in the diaspora. You are in Nairobi. You have your land in the village. You allow somebody to plant tea, to plant coffee, to plant sukuma wiki, to plant cassava, to plant onions. This is your sister. This is your uncle. This is your niece. This is your brother. This is your sister. That person is a licensee. The land is not his. You have allowed him. There is a difference between a licensee and a squatter who has not been allowed in that land. So, make sure nowadays those licensees are stealing people's land. You allow them, you don't write any form of agreement, they stay there for 12 years, then they go for adverse possession, saying the land belongs to them. Make sure anybody you allow to use your land, let it be in writing. 2, make sure within 12 years, you at least go there once. You take a selfie, you take a photo showing that you entered that land, or else a licensee can turn himself to be a squatter and you lose that land. Matrimonial home. This means any property that is owned or leased by one of the spouses of the family. This is a matrimonial home where people live. They wake up, they sleep from there, they eat from there, they sleep there, and they give their children, they give birth from that place. That is called a matrimonial home. Then we have a riparian reserve. What is a riparian reserve? This means the land adjacent to an ocean, a lake, a sea, a river, a dam, a watercourse as provided for. So if your land touches water, that area is called a riparian land. It's not your land. It is not your land. That land belongs to the government. What is a squatter? It means a person who occupies land that legally belongs to another person without that person's consent. We have dealt on that. Then we have tenancy in common. This means a form of concurrent ownership of land in which 2 or more persons possess the land simultaneously, where each person holds an individual undivided interest in the property and each party has the right to alienate or transfer their interests. In this type of ownership, me and Cyrus, we own this land. It must be indicated shares of Cyrus. Cyrus has 62%. Danson Omari has 38%. Total 100. Cyrus can opt to sell to Vivian his shares of 62%. Then now Vivian becomes a co-owner with me. Vivian also can decide to sell her new 62%. She sells 2% to Bramwell. Bramwell becomes now a co-owner with Dunstan, with Vivian and Bramwell. So in common, what is called tenancy in common, each person has a share that is known, but the ownership document is in one unit. Ni kampuni ambayo kila mtu anajulikana share zake ni ngapi. Transfer. We hear severally the term transfer. It means the passing of land or lease or a charge from one party to another by an act of the parties and not by operation of the law. You transfer willingly. You sign off ownership from you to somebody else. The person who you transfer to is called a transferee. That one receiving. If I'm transferring to Cyrus, Cyrus is a transferee. Then me, who is the owner, I'm the transferor. I'm the one who has given Cyrus that land. Then we have transmission. This means the passing of land, a lease or charge from one person to another by operation of the law on death. When somebody dies, that land must move to somebody. Transmission only happens when the owner is dead. Transfer happens when the owner is alive. So, in succession, which we'll be dealing, is transmission of property from a dead person to a living person. Trustee includes those people holding the property on behalf of a beneficiary. Valuable consideration. The valuable consideration is that any transfer of land, any buying of land, there must be payment. That is what the law says as valuable consideration. The valuable consideration does not only include money, and this is what the final terminology we are dealing with. Valuable consideration includes marriage. So if you marry from this place, you can be given land. It includes money. And therefore, that is what we have introduced to you. These terminologies are very critical because as we move in the Land Act, these are found in Section 2 of the Land Act, which we have brought to you. You now know the terminologies. When I'll be talking about these terminologies, you'll understand what I'm talking. Okili, Dan Omari, making the law simple, clear, articulate for the benefit of you, not for lawyers. Keep watching episode 2. We are now moving to episode 3, where we are dealing with the substantive law called the Land Act. Asante.